Tell me the point of that in that context.
Glad you mentioned that.
That is impartiality.
I think you're unusual. And with respect, Ben, you completely misunderstood that point.
They do it all the time.
Well, then,
I can sit there.
It's worried me a lot, actually, Ben, what you're saying.
To have two surveyors, two impartial surveyors.
Whether he likes it or not.
And how many times does the Act refer to impartiality? It doesn't.
What's the answer?
Was it so terrible to do the trade that I've just mentioned?
Hello and welcome to our podcast, which will focus on impartiality. My name is Grace and I'm joined by Ben Mackie from the Impartial Collective and retired Judge Edward Bailey, who practiced as a barrister from 1972 to 2000 when he became a circuit judge. He sat at Central London County Court from 2006 until his retirement in 2019 and was the judge primarily responsible for party wall award appeals. This podcast will start with Edward putting up his defence of impartiality. Ben will then put forward his views and will proceed to cross-examine Edward's argument. Following this, Edward will have the opportunity to cross-examine Ben's response. They will then be given the chance to provide their final words on the matter. I understand from Ben that he concedes that an agreed surveyor and third surveyor must act impartially, and that the scope of this debate relates to the party-appointed surveyors. Before we get started, I'd like to hand over to you both to get some definitions of the word impartiality. Ben, would you like to start?
Yep, so for me, obviously we need to have a basic definition of impartiality, and for me it's quite simple. It's impartiality is to treat both parties to a dispute equally.
Yes, well, I looked in my Oxford English Dictionary and was told that impartiality means not partial. That is, not favouring one party or side more than another. Unprejudiced, unbiased, fair. And that's impartiality, I think, well defined by the Oxford English Dictionary.
Excellent, thank you both. Okay, so Edward, if we start with you, tell us why party-appointed surveyors must act impartially.
Yes. Certainly, I don't see it as a defence. I see it as absolutely the case that any party wall surveyor, whether he's agreed third surveyor or a party-appointed surveyor, must act impartially when acting as a party wall surveyor. I think it would be helpful to start with some groundwork. And the first point I want to address is who or what is a party wall surveyor. Of course, there is the Party Wall Act, 1996, and a party wall surveyor will be a party wall surveyor operating under that Act. Section 20 of the 1996 Act defines surveyor and as any person appointed or selected under Section 10 of the Act. It's important to note that any person can act as a party wall surveyor except an owner. There is no requirement in the 1996 Act that a party wall surveyor should be a surveyor qualified in any way at all. And so even you, Grace, could be a party wall surveyor as long as it was not in a dispute concerned with a building of which you were an owner. Section 10 of the Act is headed Resolution of Disputes, and the operative words are in Section 10.10 for present purposes. The agreed surveyor, or as the case may be, the three surveyors or any two of them, shall settle by award any matter, A, connected to any work to which this Act relates, and B, which is in dispute between the building owner and adjoining owner. It follows that where you have two party appointed surveyors and a third surveyor, an award can be made by both the party-appointed surveyors or one or other with the third surveyor or all three surveyors. We're left, therefore, with an answer that a party wall surveyor is a person appointed under Section 10 of the 1996 Act to settle disputes, and such disputes are settled by award. We must be clear that that is the proper definition of a party wall surveyor. In the course of any surveyor's work, he or she may get involved in a whole range of matters for the appointing owner, where they are owner-appointed surveyors, which are outside the work that they do as a settler of disputes. But when a party-appointed surveyor gives advice to the appointing owner as to what the act's about, or what they might do in relation to the development that they want to undertake, they're not acting as a party wall surveyor, they're acting in a private capacity, as it were, a non-statutory capacity, giving advice and giving assistance in the way that anybody would do if they want to be helpful. The second important bit of groundwork that I wish to cover is the award. What is an award for the purposes of the 1996 Act? It is the resolution of the dispute, and its extent is determined by Section 10, subsection 12. And Section 10, subsection 12 provides that an award should cover A, the right to execute any work, B, the time and manner of executing any work, and C, any other matter arising out of or incidental to the dispute, including the question of costs. It can be seen to be exactly the same as a judgment in a piece of civil litigation. At the end of the evidence and the parties' submissions, the judge gives a judgment, and that judgment determines the issues in dispute between the litigants. At the end of the party wall surveyor's work, the party wall surveyor or surveyors issue an award, and that award is the determination of the dispute between the owners. There must be a dispute. If there's no dispute, there's no need to have an award. And there are some examples in the case law of surveyors coming unstuck because they've made awards when there wasn't a dispute in the first place. A recent example is the case of Evans and Patterson. But it's important to focus in on what the award is and the extent of the award. If surveyors were to go outside the ambit of Section 10, subsection 12, then whatever they have written, even if it's under the word award, would not actually be a party wall award. The third important piece of groundwork is the question, well, what effect does an award have? I've made the point that it resolves disputes, but it does really resolve disputes. And I stress that because of the wording of Section 10, subsection 16, because that subsection says that apart from an appeal under Section 1017, the award, quote, shall be conclusive and shall not be questioned in any court, unquote. I sometimes wonder whether party wall surveyors really appreciate the strength of that statutory provision. It is conclusive, it cannot be questioned in any court. The only way to challenge an award is by appeal to a county court under Section 1017. That subsection gives a very short time in which to bring an appeal. If you read the Act, it says 14 days, but that includes the day on which it's served. The award is served on the owner. So effectively, that's 13 days. We find ourselves with an award which is very powerful as between the parties. If you don't get your appeal in on time, or you appeal and you don't succeed, that's it. The award between the building owner and the adjoining owner cannot be questioned in any court. And just to put a bit of colour to that, there's no earthly point going off to the administrative court and saying, but look at this award, it's terrible, it's clearly prejudiced and biased, the party wall surveyors didn't do right by me in any way whatsoever. Ministerial Court will have to say, well, I'm sorry, you didn't challenge it within the 14 days. There is nothing this court can do. It cannot be questioned in a court. And therefore, I end this piece of groundwork by stressing that the award is as binding as any determination of a dispute in any other way ever could be. We've already covered what we mean by impartiality, not favouring one party or side more than the other, being unprejudiced, unbiased and fair. I have to say, I find it rather strange, having spent my entire judicial life being extremely careful never to be prejudiced, biased or unfair, never favouring one side more than another, to have to argue that a party wall surveyor acting within the scope of the Act, who can make an award as binding as any judgment I ever gave as a judge, should be able to approach his or her task in any other manner but in an impartial one. The next item of groundwork I would like to cover is the context for impartiality. It may seem easy enough to say, well, you mustn't be prejudiced, you've got to be fair, you mustn't be biased, but acting fairly and acting in an unbiased manner does require a context. So far as a civil judge sitting in a civil dispute is concerned, the context will be the law. But for a party wall surveyor, the context is the Act. As we know, the Act is brought into operation by the service of a notice. There are three types of notice that can be served. A notice under Section 1, dealing with works on a line of junction. A notice under Section 3, a party structure notice, which is served when a building owner wishes to exercise any one of the many rights he or she has under Section 2, subsection 2 of the Act. And there's an excavation notice under Section 6. The most common notice starting the Party Wall Act procedure which is served will be the party structure notice. And it's perhaps most important in this context, that of partiality, because many of the rights that are given building owners under Section 2, subsection 2 of the Act override the adjoining owner's common law rights. So you have a situation where the adjoining owner has common law rights, building owner can say, too bad, I'm going to exercise these statutory rights which override your common law rights. But the context, if one goes through the Act, and I shall do so only very swiftly, one sees that both the building owner and the adjoining owner have rights and obligations. And in a real sense, you can see the obligations on the part of a building owner forming rights on the part of the adjoining owner. For example, I've referred to the rights under Section 2, subsection 2. If you go on through Section 2, subsections 3 to 7 involve obligations on the part of the building owner to repair damage that some works may have caused to the adjoining owner's property. The adjoining owner has a right to serve a counter notice under Section 4, requiring the building owner to carry out particular works in certain situations. Then there's a very important right under Section 7.1 for the adjoining owner, and that is the obligation of the building owner not to carry out work so as to cause an unnecessary inconvenience. Even perhaps more important is the provision in Section 7, subsection 2, which provides that the building owner must compensate the adjoining owner for any loss or damage that may be caused. I'll just pause very briefly just to point out that that makes the building owner liable for damage to the adjoining owner's property. In civil litigation, one will frequently find that the builder who causes the damage is what the law knows as an independent contractor, independent of the person who employs him. That will frequently give the employer a defence against any claim brought by a person who suffers loss because of the way in which the builder has carried out his work. You might think, well, that doesn't matter if you suffer damage to your property or injury to yourself because of the way the builder does work. You can sue the builder, but perhaps too frequently the builder isn't worth suing. The builder is a limited liability company with very few assets. Here in the Act, in section 7.2, Parliament has said the building owner must compensate the adjoining owner. And that is quite an important right, not least because one starts off with the proposition that the building owner actually owns the building that he's doing work on. I won't go into the problem of mortgages and so on. But then there are other rights that you'll find in section 7.3, the need to put up temporary hoarding and shoring up the adjoining owner's property. Then there's the section 7 subsection 4 provision which provides that the building owner may not use special foundations without the consent in writing of the adjoining owner. And section 7.5, the building owner must not deviate from the plans or sections or particulars as set out in the award. And finally, there's a range of provisions in section 11. The point I'm trying to get across is that the Act sets out a whole range of rights and obligations on the part of both parties. It has, on a number of occasions, been described by judges as providing a complete code which takes party war work outside the ambit of the common law, and I think there's a lot to be said for that. So what is the importance of this context? Finally, I get to the point I've been driving at. Here you have an Act of Parliament which sets out rights for a building owner, which override common law rights to carry out work, also sets out rights relating to line of junction and excavation. And throughout the Act, you will see that there are rights and corresponding obligations, that there is a code protecting both parties' interests. And so, where you have an Act which, within its own four walls, balances rights and obligations of the owners, allowing a building owner to do works that he wouldn't otherwise been able to do, but at the same time protecting the adjoiner's owner's interests. This whole context requires, I might say, demands that the determination of any disputes between the building owner and the adjoining owner must be resolved in an unprejudiced, fair and unbiased manner. It would, I suggest, be quite absurd to have an Act of Parliament which goes to great trouble to balance the rights of the two owners and then say, oh, but when it comes to resolving a dispute, it really doesn't matter if the party wall surveyor doing the dispute does it in a prejudiced, biased, improper manner. It seems to me that it would make a nonsense of the Act. It might be said, and I have no idea what Ben's going to say, well, the Act doesn't actually say that an award has to be unbiased and not prejudiced. And maybe that's a big mistake of Parliament, but there is an assumption on the part of our legislators that people undertaking a dispute resolution process should actually know how to behave. So that is the essential argument. You've got this Act carefully balancing rights and obligations. Where there's dispute, then there should be a careful balance of the resolution of that dispute. And I go back to the definition of surveyor. As I said, when started, anybody can be a party wall surveyor. except the owner. Why can't the owner be his own party wall surveyor? Incidentally, just in case the real cognoscenti listening to this podcast think I've missed something, I also appreciate that if there's a dispute as to who should be the third surveyor, and you go off to a local authority appointing officer, the appointing officer may not appoint a third surveyor if one of the owners is an employer of the appointing officer, has to go off to the Secretary of State. But let's just stick with surveyors. An owner cannot be his own party wall surveyor. And why not? I mean, if the Act were prepared to tolerate a party wall surveyor determining a dispute in a partial, biased, prejudiced manner, well, why not allow the owner himself to do it? If a party wall surveyor doesn't have to be independent of the parties, and independence, of course, implies impartiality, why not allow the owner to be his own party wall surveyor? Because after all, who better to look after the interests of the owner than the owner himself? If impartiality is not required of the independent party wall surveyor, one could end up with a rather bizarre situation. The Act would effectively be saying, well, Mr. Owner, you can't be your own party wall surveyor because you might be biased and prejudiced in your own favour, and that wouldn't look right. But don't worry, you can appoint Mr. Mackie here, and he can be as biased and as prejudiced as he likes in making the award. And that really would make a complete nonsense of the definition of surveyor. Finally, you'll be pleased to hear, I come to the law. I leave the law last and because I like to develop the argument simply on the basis of the Act. But whether he likes it or not, the party-appointed surveyor is just as covered as an agreed or third surveyor by the decision of the Court of Appeal in Grey and Elite Town Management Limited, in which Lord Justice Jackson approved the very well-known dictum of Mr. Justice Brightman in Guile, Thompson and Wall Street Properties, where the then Mr. Justice Brightman, who later became Lord Brightman, said that a party wall surveyor is in a quasi-judicial position with statutory powers and responsibilities. In both Grey and Elite and in Guile Thompson, the courts were considering the position of party-appointed surveyors. Quasi means as if, so quasi-judicial is as if a judge. Must a judge act impartially? Interestingly, there's no statutory requirement for a judge to act impartially. Judges hold office under the Crown and therefore not covered directly by statute. But all judges have to take the judicial oath on their appointment, and the operative words are, "I will do right to all manner of people after the laws and usages of this realm without fear or favour, affection or ill will." There is no doubt a judge must act impartially. A party wall surveyor as a quasi-judge must therefore act impartially. I don't forget, however, that when introducing the Party Wall Bill into Parliament back in January 1996, Lord Lytton described the role of the Party Wall surveyor as quasi-arbitral, as if an arbitrator. And as by way of a side note, you will find that in several of the old cases, late last century, beginning of this century, the surveyors were described as arbitrators when making an award. So Parliament passed the Party Wall Act on the basis that party wall surveyors were quasi-arbitral. And Parliament would, or certainly should, have understood that this carried with it a duty to act impartially. Why? Well, the very same year, 1996, was the year in which the Arbitration Act 1996 was passed, and Section 33 of the Arbitration Act specifically requires an arbitrational tribunal to, quote, act fairly and impartially as between the parties, giving each party a reasonable opportunity of putting his case and dealing with that of his opponent, end of quote. So whether it's quasi-judicial or quasi-arbitral, the party-appointed surveyor must act impartially.
Thank you. Thank you. Ben, over to you.
I think we've run out of time. Right. I mean, what's brought us here today is the fact that I've written an article called The Impartiality Myth, which is in this book, and there's a second book coming out where Edward has kindly given an article called No Myth, the Party Surveyor Must Act Impartially. So I think it's quite nice that we're here today to have this debate on impartiality.
And publicise your book.
And publicise, yes, Party Collective and all that. So, when it comes to impartiality, I do firmly believe that an agreed surveyor and a third surveyor need to act impartially. My reason for this comes down to common sense and natural justice. I think we can all accept that if you've got two parties to a dispute and they put that responsibility of resolving a dispute into the hands of one person, then it's perfectly reasonable to expect that that person will deal with the dispute by acting impartially, to treat both parties equally, okay? And again, the same can be said of a third surveyor. The third surveyor is called upon to settle differences between appointed surveyors, primarily, and these surveyors will make submissions to the third surveyor, and they do that in a reasonable expectation that the third surveyor will treat both of them equally. But I'm yet to be convinced that party-appointed surveyors are required to act impartially. And again, I come back to common sense and natural justice. With party-appointed surveyors, we know that the dynamics are different. A building owner surveyor does not have the sole responsibility of resolving the dispute, and therefore there's no requirement to treat both parties equally. A surveyor appointed on behalf of a building owner has different objectives to a surveyor appointed on behalf of an adjoining owner. I would suggest from experience that building owner surveyors must be competitive to get work, and competitiveness comes from cost, where we can obviously see a race to the bottom with cheap awards for 450 quid or whatever it is. Time, where we can see pressure on a surveyor to deliver the awards quickly to meet deadlines, and quality, where some people seem to want a decent surveyor and they're willing to pay a bit more and they want a safe pair of hands. The adjoining owner surveyor is very different. Cost and time don't matter. So an adjoining owner surveyor tends to always be more expensive than their building owner surveyor's counterpart. There's no rush for them to agree an award or to hit any deadlines. And you may find that the adjoining owner simply wants quality. And as the building owner is expected to pay, price isn't a factor. Against this backdrop, common sense should lead us to understand that there will be friction and that parties will not be treated equally. The surveyors, they have different agendas. We need to understand and accept this, and then we can find that maybe expectations are managed a bit better. We may also find, perhaps surprisingly to Edward, that the party wall process may work out more fairly. If party-appointed surveyors and their respective appointing owners understand the differing roles, we may well see a higher uptake in agreed surveyor appointments, because there are far too few of these appointments at the moment. If parties can understand the different routes to having their dispute resolved, they would appreciate the uniqueness of the agreed surveyor role, which is to have their dispute resolved by an impartial surveyor. By taking away this uniqueness and applying it to party-appointed surveyors, parties are blindly appointing what they believe to be two impartial surveyors, when in reality these surveyors are anything but. Surveyors are likened to judges, with the phrase quasi-judicial often used. And like judges, many surveyors believe that they've got immunity from suit, is it? Suit? Immunity
That's right.
from suit?
Yeah.
I wasn't sure, yeah. And that they can't be sued for negligence, right? To this I would say, be very careful, because quasi comes from Latin and it means as if, which is what you've said before as well. And yet the RSCS found that the disciplinary panel of a certain Mr. Antino, that he did not have immunity from suit as a party wall surveyor. And they did this by noting the differences. So the differences far exceeded the similarities when it came to comparing the Party Wall Act and judicial proceedings. For example, a party wall surveyor investigates rather than adjudicates. This is a non-judicial function. So if you compare the requirements to be a judge with the requirements to be a party wall surveyor, I mean, tell me that those requirements are the same. I could get the cameraman, all right, over there. I could get you to be a party wall surveyor today, right? I couldn't get him to be a judge any time too soon, I don't think.
No, quite simply.
But you know, Edward, better than most, right? With everything that you went through to become a judge, that the role of a party wall surveyor is completely different. And to refer to a surveyor as quasi-judicial really puts the surveyor on a pedestal. I tell my father-in-law that I'm quasi-judicial, right? And that's to impress him, okay? And you know, he loves me for it, but he loses all respect when I tell him that I didn't need any qualifications or experience to do my job as a party wall surveyor. So, you know, I'm working on him. But make no mistake, surveyors are not judges. We're not close to being judges, and surveyors can get sued. I think you would agree, possibly, Edward, that surveyors can get sued.
Oh, I agree you don't have immunity from suit, but the way in which you can be sued is maybe more limited than you would find yourself if you were acting in a non-party wall situation.
Yeah. I mean, look, what we've got really in terms of immunity as well, and this I think is quite important. In Taylor v. Serious Fraud in 1999, Lord Hoffman stated that the policy of the immunity is to enable people to speak freely without fear of being sued, whether successfully or not. And for any surveyors out there that still think that it's okay to hide behind immunity, they should at the very least understand that immunity was removed from barristers in 2002 in the case of Arthur J.S. Hall v. Simons, and for expert witnesses being sued by their own clients in 2011, and that's in the case of Jones v. Caney. So I think if surveyors were truly expected to act impartially in their quasi-judicial role, they would be considered immune from suit to protect their ability to act freely. And that is something that judges enjoy. The mistaken belief that surveyors have immunity can cause them to hide behind it, so they feel that they're not really answerable for their actions. They see themselves above the law, which isn't the case, and quite rightly so. Surveyors need to administer the Party Wall Act correctly and understand there can be consequences if they get it wrong. A lack of immunity can ensure fairness and accountability. So who wouldn't want that? Aside from the fact that surveyors are not anywhere near judges, they're not quasi, they're not as if judges or anything close to it. They don't enjoy immunity, but they are bound by the Act to act effectively. Additionally, whilst a surveyor's appointment cannot be rescinded, the Act is not silent on surveyors' behaviour. The Act gives very clear instructions on how a surveyor should act. And if it was that clear that a surveyor should act impartially, then the Act should really refer to that. You would think that, listening to Edward, that impartiality is referred to throughout the Act. And how many times does the Act refer to impartiality? It doesn't. It doesn't mention it, nor does it mention heroically acting for the wall. Instead, the Act places the obligation of a party-appointed surveyor to act effectively. That's the key word. And this is referred to in sections 10.6 and 10.7, whereby a surveyor can actually be bypassed if he refuses or neglects to act effectively. So what does effectively actually mean? For me, party-appointed surveyors are acting effectively if they are liaising with their respective owners, understanding their concerns and then negotiating an award that comprehensively deals with those concerns, so long as they're within the surveyor's jurisdiction. So it's perfectly acceptable for a building owner to want access onto neighbouring land, and it's perfectly acceptable for the adjoining owner to want to have that access restricted somewhat. The building owner surveyor should be expected to make a case for access, while the adjoining owner surveyor, understandably, would be expected to keep those requirements for access in check. It's also absolutely fine for an adjoining owner surveyor to ask for £5,000 for the contribution towards a wall that was built by the adjoining owner, where a building owner wants to make use of that wall. And again, the building owner surveyor might say, well, actually, I would like to offer you £3,000 for that wall. This is all perfectly acceptable. It's a normal part of the process. It's what us party wall surveyors are actually used to dealing with on a day-to-day basis. The building owner surveyor should fight for the building owner. And likewise, the adjoining owner surveyor can fight for the adjoining owner. Let's go back to that £5,000 that I mentioned, where an adjoining owner surveyor has requested that amount for a wall that was built by his clients, and the building owner wishes to use it. And that's commonly known as an enclosure payment under section 1111. Does anyone seriously think that the building owner surveyor would say to the adjoining owner surveyor, wait, I'm impartial. I say we should be paying £6,000 for the wall. You've come in too low. I treat both parties equally. And if that does happen, does anyone seriously think that an adjoining owner surveyor would say, I'm afraid I can't accept this. You see, I'm impartial too. It never works like that. Can you really take a collaborative approach to impartiality? The key to impartiality is independence, after all. And I think where we have party-appointed surveyors, if they can understand that they have different agendas, they can come together to find common ground to resolve the dispute. A party-appointed surveyor can discuss the dispute confidentially with his appointing owner. A building owner surveyor might advise the building owner how to reduce the scope of the dispute by altering the design. An adjoining owner surveyor has a different hat on. He needs to be extra cautious. He will discuss monitoring, security for expenses, a checking engineer, a flue survey, and these are not the things that a building owner surveyor would want to put forward if he weren't asked. So tell me, where is the impartiality? How can we possibly say that a typical building owner surveyor treats both parties equally, and how can we say that of the typical adjoining owner surveyor? We know we can't. So we need to move on from impartiality and accept reality.
Thank you, Ben. Thank you. Edward, over to you. Do you have any questions?
Yes, I've got some questions. You referred, Ben, to the provisions of section 10.6 and section 10.7, which provide that where one party appointed surveyor either refuses or neglects to act effectively, then the other party appointed surveyor can prepare the award ex parte. Is it your contention, Ben, that when the sole party appointed surveyor does an ex parte award, he's allowed to be as partial or as prejudiced or as biased as he likes, or should he act impartially?
So what we have there is 10.6 and 10.7 are very different in terms of the power that they give a surveyor to deal with an issue. For example, in one of the sections where there's a refusal to act, they can actually go on to make an ex parte award, whereas when they neglect to act, they can only deal with that subject matter for which that neglect took place. Yeah, so there is, I would say, quite a big difference there. We also know that there's a huge difference, I would say, with the word introduced to 10.6 and 10.7, which is different from where an agreed surveyor, I think it might be what is it for agreed surveyor? But if an agreed surveyor refuses or neglects to act, they can be removed, right?
Subsection 9.
Whereas where you have the two surveyors, it's a case of if they're refusing or neglecting to act effectively, and it's that introduction of the word where I would say that's the difference between the two surveyors and the two sections, right? And I think it's a really important word.
We'll differentiate subsection 6 and subsection 7. What's the answer?
So the answer is that if you are a party appointed surveyor to start off with, you don't need to act impartially. When it comes to bypassing another surveyor, you should, to start off with, go to the third surveyor. If you are then going to do an award, based on the circumstances that you've said, I would suggest you have to then put a different hat on, which is what surveyors do all the time. I've got my agreed surveyor hat where I'm impartial, then I've got the party appointed surveyor hat where I don't need to be. So in that particular case, if I'm going to do an award, I understand that ex parte awards are probably possibly the most appealed awards, as are party appointed awards, right? I can't remember a time.
Maybe.
When was an agreed surveyor award actually appealed?
Oh, I've come across appeals of
But what
agreed
I'm saying
surveyors.
is it's extremely rare, and that's very, very relevant to the answer, especially with impartiality. You'd think with two impartial surveyors, the appeals would decrease, wouldn't you?
I'm not sure any rules apply actually when it comes to appeals. We haven't yet mentioned section 10 subsection 2, which is important, provides that all appointments and selections made under this section shall be in writing and shall not be rescinded by any party. So a party appoints Mr. Smith as his surveyor. He doesn't like him. He's not prejudiced enough. He's not biased enough. He's just not effective enough. So on your bike, Mr. Smith, I want Mr. Jones. Why does the Act say he can't do that?
So that's obviously a question about how an appointment simply cannot be rescinded.
What is the point of saying that you're having appointed a surveyor, you may not rescind that appointment?
No, understood. That is obviously to give the surveyors some protection to carry out their duties freely. So, you know, there you have the immunity style sort of argument of, you know, the freedom to act with impunity almost. But I would also remind everyone that when it comes to a surveyor's behaviour, whilst it cannot be rescinded, we have previously mentioned 10.6 and 10.7 where there's a refusal or neglecting to act, and that governs a surveyor's behaviour. So there is a recourse for an appointing owner that's not happy, and you've got to, I would say, remember, in Gray v Light Town Management, I think it was you that specifically said that you need to search far and wide to find a surveyor that would have the same views as a Mr. Gray. And I mean, tell me the point of that in that context.
Glad you mentioned that. It's in your article, and with respect, Ben, you completely misunderstood that point. What was happening with Mr. Gray is that he had very strange views about basement construction. Mm-hmm. And the quotation from my judgment, which I did check yesterday, was that although he would have to search far and wide, and what happened, just for the listeners, is that, and why the whole litigation started off on such an appalling footing, is that Mr. Gray was cheated out of getting an appointment because they served him at an address where he never got the notice. And they didn't put a notice through the front door of the property where he would have picked it up. So they make an appointment. The building owner makes an appointment for Mr. Gray as adjoining owner. Mr. Gray as adjoining owner has very strange views on basement construction. And I make the point that you have to search far and wide to find a surveyor with the same views. But what I say in the judgment is that they should have at least looked for somebody who was prepared to listen to the views and have some sympathy. That's the only point, because they appoint somebody who simply had virtually no dealings with Mr. Gray. And that was really, it added insult to injury in that particular case. So it's not, you cannot take those comments I made as suggesting that when you make an appointment for the other owner, you've got to find somebody who shares that other owner's views. Apart from anything else, you wouldn't know what the owner's views were. But,
the surveyor appointed on behalf of Mr. Gray acted impartially, really, by serving an award that went against Mr. Gray, really. So that is impartiality. And that just goes to show impartiality in a party-appointed scenario
we're at serious risk of being off-piste. What the party-appointed surveyor did for Mr. Gray was completely neglect to tell Mr. Gray about the provisions of Section 7.4. And what he did, because A, Mr. Gray told me and I believed him, but B, and this is so important, he signed off an award which permitted Elite Town Management Limited to build a basement construction with special foundations without ensuring that there was an agreement from Mr. Gray to quote the Act in his consent in writing. And no competent party wall surveyor will sign off on an award with special foundations without ensuring that there is a written consent from the adjoining owner. And that is where the surveyor appointed by the other side lamentably failed to act properly. Forget impartiality. He was not impartial.
So the thing here is, you said that Mr. Gray told you something, you believed him. The surveyor wasn't called as a witness, so therefore
the judge has no control over who's called as a witness.
No,
absolutely
exactly.
right.
So that would be a slight weakness there in that finding.
Forget. I saw Mr. Gray in the witness box. He also acted as his own advocate, and he was actually pretty good.
I'm sure
he had Nick Isaac behind him, but nevertheless, Mr. Gray felt very strongly indeed that the basement construction should not involve working under the party wall at all. But had Mr. Gray been told by his surveyor that Section 7.4 of the Act expressly prohibited the use of special foundations without his consent in writing, there is no way he would have given that consent. And that is why when Mr. Gray told me on oath that he hadn't been advised, I readily believed him, because he would have exploded. Well, he would have been thrilled to be told it, because he'd write to the other side, well, forget it.
Yeah,
I
think they introduced that little blob of, foundation underneath.
Well,
so
he then behaved very questionably, because in order to prevent elite town management from building its basement construction, he then started drilling holes in his retaining piles, so that whenever they were going to put concrete down, it would have escaped into his basement. His subsequent behaviour was nothing I would condone. But it's very important to read the facts of that case very carefully.
No, understood.
You made what I saw as a rather bad point about Section 1111, and well, the building owner come along and say, well, I want £5,000 for this wall, and the adjoining owner say, well, £3,000, and you say, how can one act impartially there? The point is, you've got to act properly to act impartially, and it's not a question of horse trading. When the original adjoining owner makes use of building owner's works, he's got to pay a proper sum for those works. And there's got to be a proper sum, and the Act actually says it has to be calculated by reference to the date on which the subsequent work is done, not the date on which the original work is done, and it's got to be done by reference to quotes. So you can't say, oh, 5's free, no, well, we'll settle at 4. No,
but
you've
that's
got to
what
have...
surveyors do to save
well, they
time.
shouldn't. Well, then they shouldn't.
Oops.
Because they should either say, I should either get quotes, or, assuming that they are competent chartered surveyors and know about building pricing, they would look at the wall and say, well, this wall is X cubic meters of concrete with so much reinforcement, and the labour is going to take 20 days to build it, and calculate it all out and say, my pricing tells me that that wall built today would have cost £5,000 or £7,000. What they can't do is just do a bit of horse trade. What shouldn't do is a bit of horse trade.
I think they do it all the time.
Well, then,
this
worried me a lot, actually, Ben, in what you're saying. In effect, you're saying, well, we don't act impartially in practice, so why should we be required to act impartially? Because you shouldn't be doing this.
But what happens in practice is, Surveyor A will come up with their calculations, including all sorts of things, that sometimes might be a bit questionable, so that they have a higher price. They will include architect's drawings, for example, VAT and various things, which is fine, right? But some surveyors, there's so many different ways of working out an enclosure cost to be paid, right? That actually, there is nowhere where you can find a simple formula that makes common sense. Like the professional bodies, as far as I'm aware, they haven't released guidance on how to calculate these things, what's reasonable, what isn't. And the reason why they haven't done that is because there's so many different ways, and it's perfectly acceptable for one surveyor to come in under because they did their calculations. And I'm saying, yes, actually, you do your little trading. Quite frankly, if I've got a figure of £3,000, another one's got £5,000, we probably will just meet at £4,000. Otherwise, where are we going to go with this? Should we just go to the third surveyor? Was that cost-effective way of dealing with it? Was it so terrible to do the trade that I've just mentioned?
I appreciate there's always going to be a margin of appreciation when you're doing a calculation of cost of building work. I quite accept that. And that two perfectly honourable surveyors behaving properly can come to different figures. There would then need to be discussion to arrive at an agreed figure. But if one surveyor has put in something into his calculation which he knows full well is a try-on and shouldn't be there, and the other surveyor doesn't spot it, then it is quite wrong, and you're not acting impartially if you allow that to go through as the figure that is awarded. It's the sort of problem that I faced with Welton McKeeve, where the costs of calculating, the manner of calculation of the work that the original building owner, now adjoining owner, had carried out when it was to be a question of payment by the new building owner, was done on a completely different basis from the way in which the cost to the building owner of carrying out the work that was eventually carried out, and which the third surveyor made an award. It was £148,000, I think. And by the time the expert surveyors had gone through it, it was not right down. I've forgotten quite figure it was at the end, but almost £100,000 worth of excess. That's not acting impartially. You
said that basically if a surveyor is giving advice, right, that advice that they give is not acting as a party wall surveyor.
That's right.
Is that billable? Is that a reasonable price within, like,
right. It's if Mr. Smith, the owner of 23 Acacia Avenue, appoints Mr. Jones as his party wall surveyor, and in the course of that appointment asks questions and gets advice, then there's it's up obviously to the party wall surveyor and the owner to decide whether there's going to be any charge for it. And the better example would be where the adjoining owner has an appointed surveyor and asks for advice as to what the Party Wall Act's all about, what the construction going on next door is about, and whether construction could be done differently. That is not a matter in dispute between the parties. So if the adjoining owner's Party Wall surveyor is going to bill for that, the adjoining owner's got to pay it. He can't add it or include it in the costs that he's going to pass on to the building owner.
Literally no one does that.
Well,
I get timesheets all the time with like, I took a phone call, we went through the act and stuff, and it's like, so really the building owner is paying the adjoining owner's surveyor to have a conversation to educate the adjoining owner about the ins and outs of the act. I personally think that that's quite reasonable, by the way. I actually think that that is the duty of a party wall surveyor, but it's just that you, for your argument in relation to impartiality, suggest like sort of almost differentiated
of course,
the two.
Because you're not acting as a party wall surveyor, because a party wall surveyor, properly defined, is a surveyor who is appointed for the purposes of Section 10, and Section 10 only governs disputes between the owners. So as soon as you start doing work which is not a matter of dispute, then you're not acting as a party wall surveyor. Now, I can accept there are grey areas in the sense that when a dispute arises as to a particular item of work and the party wall surveyor is acting for his appointing owner and explains the nature of the dispute by reference to the work as a whole, well, that is probably, I can't say definitely, but is probably in any particular instance work relating to or arising out of the dispute and would therefore be passed to the building owner. But one can surely imagine a range of cases where advice is sought by an adjoining owner of his party-appointed surveyor that really has nothing to do with the dispute. And the adjoining owner, if he's acting properly, should not seek to pass the cost for that work onto the building owner. It's simply not right. It doesn't arise under Section 10.
I was really interested by your case of Amir Siddiqui versus
Kovalich.
Yeah, I would have said Kowaliu. Anyway, so that was 2018. I love that case. I really do. But what I was curious about was the idea that that Polish guy.
Yes, Mr.
Can't say
Kovalich.
his name. He's been found to have acted unreasonably in the sense that
He didn't act unreasonably.
Not by merely appointing.
He acted in such a way. This is an important distinction. I'm afraid perhaps our discussion has shown the difference between a surveyor and a lawyer, and it may be I'm a boring pedant, I'm sorry. But there's a difference between acting unreasonably and acting in such a way that you give rise to unreasonable costs. Now, it's a pretty fine distinction, but the point in Amir Siddiq is that Mr. Kovalich insisted on having his own independent appointed surveyor, and Miss Amir Siddiq, anxious to keep costs down, went to that surveyor and said, would you please act as agreed surveyor? He ummed and erred, I recall, but he eventually said, yes, I'll act as agreed surveyor. And Kovalich said to him, no, you may not act as agreed surveyor. And as a result of that, which he was entitled to do,
Yeah, agreed.
perfectly entitled to do that, but by acting in that way, the costs that he eventually wanted Miss Amir Siddiq to pay were unreasonably high. Because had he, in my judgment, had he agreed to his surveyor acting as agreed surveyor, the costs would have been less. And so I deducted from his costs the costs that Miss Amir Siddiq incurred in having to get her own surveyor, quite unnecessarily.
So really what I'm leading to there is, especially for residential jobs, which is primarily what I'm involved in, when is it ever reasonable to have a party-appointed surveyor? I mean, we always push for the agreed surveyor route myself, that's what I do. Happy to lose the money on that, happy to literally have it resolved with one surveyor, no worries at all. When is it ever reasonable?
I think you're unusual, actually. I think many surveyors prefer just to be party-appointed surveyors. You've opened actually up quite a big question. There's an interesting talk which I think's been recorded, Nick Isaac gave, about when it's sensible and when it's not sensible to act as an agreed surveyor. And there's a lot in that which I agree with. But the first point is this. Miss Amir Siddiq was unusual in that she was very anxious to have an agreed surveyor and agreed to appoint the other guy's surveyor as agreed surveyor. And that is unusual. And if the building owner appoints a surveyor, tells the adjoining owner, here's your notice, you should appoint a surveyor, and the adjoining owner goes and appoints his own party-appointed surveyor, the question of agreed surveyor simply doesn't arise. And it's not open.
Why does it?
It's not open to a judge
in
to
my
say.
Business.
Well, okay. Well, then, with respect, I believe you're unusual, but maybe there are loads of surveyors watching this who say, "Yeah, I always try and act as agreed surveyor." But
I mean, our notice acknowledgement form has a box. Tick this if the surveyor that you have picked, you're happy for that surveyor to be the agreed surveyor.
Okay.
And we're not even appointed until there's a dispute. So therefore, it's all set up in such a way that it almost has to be reasonable. I mean, why could you ever go down the party-appointed route to have two surveyors, two impartial surveyors in this scenario?
I mean, there may be loads of reasons. I mean, the second owner to appoint, presumably the adjoining owner, might ask his mates and say, do you know this guy? You know, Jenkins is a surveyor. And they say, oh my goodness me, I didn't touch him with a barge pole.
But the adjoining owner should never disagree, if that makes sense, because they're the ones that pick the surveyor. So if the building owner is happy for the agreed surveyor, on what reasonable basis could the adjoining owner ever refuse?
We're operating at cross purposes. Assuming a building owner appoints his surveyor first, which is usually the case.
Never the case in my practice, never.
Okay, because so often, almost invariably, not always, but when I've come across party wall cases, the building owner appoints the surveyor who then serves the notices, and until the notices are served, then the adjoining owner doesn't know what's going on. So the building owner has a surveyor before the adjoining owner knows anything's going to happen.
I mean,
and that's why
for me, we're not appointed, there's no dispute. So we serve notice as an agent, we make it really clear that the adjoining owner can respond, pick their own surveyor, and then because they've picked that surveyor, surely they must be happy enough to have that surveyor as the agreed surveyor. And it comes down to whether the building owner is happy to sort of, has a sensible surveyor being picked, really.
Okay, but I think human nature being as it is, there are all sorts of reasons why a particular owner might not want a particular surveyor.
Agreed.
But in my experience, it's obviously very different from yours. I do appreciate that, and far less hands-on. I mean, I've never acted as a party-appointed surveyor. I've acted as a third surveyor, but never as a party-appointed surveyor. But to say it must always be unreasonable for the second party not to agree the first party's appointment and so prevent there being an agreed surveyor is in my view, a very dangerous concept.
Remove the word always to almost.
Almost always.
Almost
Sorry,
always. Yeah, keep always.
Even almost. And there's so many reasons why I would have thought why the second appointer will not want to take the first appointment as an agreed surveyor. Certainly, I can't see that a judge can properly say that whenever there are two party-appointed surveyors, then one or other party has acted unreasonably in not agreeing with the appointee of the other.
I don't think you can say that of the building owner, definitely not, because they're paying. But I think you can say that if the adjoining owner has picked a surveyor and the building owner is more than happy to go with that surveyor, if the adjoining owner refuses, I find that to be generally unfair.
Okay.
Generally.
Okay, I do think that...
And that does come down...
There are risks in being an agreed surveyor where the work involved is really quite complex.
Agreed.
And I was surprised when you said that you suggested that there were very few appeals against agreed surveyors' awards.
I believe so. I've got no statistics.
But this is my experience. No, I've done a fair number of appeals against agreed surveyors. I think you've got to.
No, fair enough. Right. Shall we conclude?
Yes.
Yeah. Shall we have closing comments?
Are really very short and to the point. I presented the argument for why all surveyors should be impartial, and I make the point that the Act is a careful balance between rights and obligations, and I make the point that whether we like it or not, the Court of Appeal has said that party-appointed surveyors act in a quasi-judicial way, which must necessarily involve impartiality. And the fact that Mr. Mackie here has not had the experience and training of being a judge as I had, nor go through the appointment process, is a matter for Parliament. And what Parliament has done is in a very narrow area of the law. And let's face it, party walls are important to party wall surveyors and to somebody like myself, but for the average member of the public, it's a teeny tiny area of the law, and the Parliament has said within this teeny tiny area and within a very limited ambit, go back to section 10.12, the party wall surveyor does resolve disputes, and that's for Parliament. Remember also that anybody can act as an arbitrator, and there's no qualification required. I mean, there may be situations where parties agree only to appoint people of certain qualifications, but as a general rule, anybody can act as an arbitrator, and that can cover any field of life. So why you should be at all worried about acting as if a judge or as if an arbitrator on a teeny tiny area of the law, it really shouldn't worry you. Both the Act looked at in the round and the courts in considering the Act have said there should be impartiality.
Okay, and Ben?
My view is that I haven't been convinced that as a party appointed surveyor I need to act impartially. You know, it's not a matter that can really be referred to a third surveyor, it's the actions that actually matter of a surveyor. I think that means everything, it's the actions. So I think you do need to have different perspectives. You need to understand essentially who you're appointed for and what you're doing, what the aim is. If you are an agreed surveyor, you need to be responsible, you do need to act fairly, and that's completely common sense, understandable. You know, you're being entrusted to resolve a dispute of two parties, so, you know, let's be fair, understood. Again, when I take instructions from a building owner, the whole process is different, and I'm going to treat people differently in the sense that with a building owner, there are pressures to get things done nice and quickly, streamline it, and try to get that project up and running with minimal fuss. Again, when I'm an adjoining owner, I will act a bit differently, I would say, and that's because I'm now an advocate towards someone that has building work next door. They've got some concerns, and I really need to make sure that those concerns are taken on board and reflected by having, you know, good representation in myself. Acting effectively is the thing that keeps me in check. So if I say that I'm not acting impartially, people don't need to worry. I'm acting effectively within the meaning of the Act. I'm interpreting the law. I'm putting the law out there, you know, to my appointing owner. I see that as a duty, you know, that I need to be undertaking. I see that as absolutely vital. So, like, we're not going to be treating parties equally. You respect the party that you're appointed for. Of course, you respect the other side as well. But primarily, you are, you know, that advocate to one side, and you let them know what the law is and how it affects them and what can be done as well, you know, to deal with the scenario. So, you know, you're really, that's the whole purpose of, you know, acting effectively. That's the thing that keeps surveyors, I would say, well behaved, reasonable, fair, and that's where natural justice comes in. So I don't think we need impartiality. I don't think it's a disaster if a surveyor doesn't act impartially, because I see it every single day and it doesn't particularly bother me in the slightest. The reality is we go through a process and then we've got the safety net of a third surveyor who does act impartially.
Fantastic. Okay, well, lots to say there. Very heated, but incredibly interesting.
We were quite civil.
I know. I thought you were civil.
Well,
Thank you,
there was an
Grace.
atmosphere, but it was beautifully done and wonderfully put across from both of you. So brilliantly. I did notice. No, thank you both so much. It's been really, really interesting to hear. Edward, it's wonderful to see you. Thank you so much. It's been incredible to have you here. I'm not sure Ben would agree with me just as much there. But no, it really has been such a conversation. We really hope that you join us again. There's lots to talk about. As we have seen. To those of you that have watched, thank you so much for joining us. If you do have any areas that you would like us to discuss moving forward, get in contact with Ben, and we'll be really interested to hear from you. Thank you all so much.
Thank you.
Thank you. Cheers.